So I wanted to talk to you today about the hold harmless agreements that are circulating around, amongst members and brokerage firms, and in fact some provisions that CVR-MLS will have available to use if you so choose. First of all, let's just start and describe what these forms are. There are some agents and brokerage firms that are asking their clients or prospects or others to sign a form which is a hold harmless agreement saying that if they catch the coronavirus, that they will not sue the agent. To be honest with you, those forms are probably of little value when it comes to shielding you from liability. Most importantly, it would be just about impossible for one of those clients or prospects, whatever, to really prove in court that the reason they obtained or caught the coronavirus was because of a showing. How do you really prove where that came from? And so that's why I think from a causation standpoint in court, it'd be really hard, and many attorneys agree with that position. Also, what are the damages, monetary damages? How do you prove that in court? So while it sounds like it's a great idea, it may take time away from the transaction or get people kind of in a tizzy signing this form when they really don't need it. And I really don't think it's going to protect you because I really don't think it's needed. Frankly, I think you have more liability as a Realtor member in the day-to-day transaction of completing the forms correctly and making sure you adhere to DPOR rules and things like that. I think that's where you actually have more liability on a day-to-day basis. I don't think you have very much liability, if at all, related to the coronavirus. I've never heard of such a case. To me, it's the same thing as, catching the flu. Have you ever heard anyone get sued because they gave someone else the flu? And I realize the coronavirus is certainly more deadly and is in the news, but it's still just an issue of how do you prove causation? How do you prove that you actually obtain the coronavirus from a showing or from an agent or from whatever, and that they turn around and sue you? So I really don't think the form the provisions are necessary. If you decide you really want it though, CVR-MLS does have two provisions that you can use, and one is for the listing agreement and one is for the buyer brokerage agreement, because that's where they really belong. It's really about to your clients and then to showings. Here's what you're going to do. You're going to indemnify me if you catch the coronavirus. So that's where they belong. It is not the purchase agreement, by the way. So if you're going to use these provisions, again, either put it in the listing agreement or the buyer brokerage or do an amendment to those particular documents. Okay. If you do property management, then you can use the paragraph in your property management agreement. You can also use it in your tenant representation agreement that says, again, that they'll hold you harmless. So, but I want to repeat, I do not recommend that you use these provisions. I don't think they're necessary, but if you choose to use them, that's why CVR-MLS has made them available. Now, the second type of document I want to talk to you about today is not related to you and the pandemic and being indemnified. It's really more about the closings. We've got a number of questions in where at the closing table that a buyer is asked to sign a gap indemnity agreement or a seller is asked to sign the same thing. And let's explain what that is. So basically, a title company is willing to insure the transaction, and if there's a gap or delay in the recording of the documents at the courthouse, that could mean that an intervening lien, a lien from the seller, gets recorded or some other issue develops. And so the title company says, hey, we'll allow you to close. In fact, you can even disperse the funds and we'll cover the transaction with respect to the lender, but we want the seller and the buyer, and if possible, the lender, to indemnify us, that is, reimburse the title company for any losses they sustain if there is an intervening lien or judgment that is recorded after closing. Those documents you should really have your clients discuss with their closing attorney or settlement agent because they can basically shift responsibility or liability from one party to the next. If you're representing a buyer in particular, my advice is that they definitely speak with their attorney. Most buyers' attorneys are advising their clients not to sign these. Why should the buyer accept responsibility or liability for something that could be a seller lien? Most lenders, just about every lender I know, are saying, no, we're not signing these. We're not indemnifying the title company. So they're refusing to sign. And then that leaves the seller. There are some situations where it makes sense for the seller to sign it and to move on for closing. But again, they should talk with their closing attorney. So that's a separate and distinct. These are called gap insurance indemnity agreements. And that is very specific to a transaction between the buyer and seller at closing, and they should get their specific advice whether or not to sign those documents.